You're listening to Lone Star Community Radio on 104.5 KCZWLP Conroe and 106.1 KZCCLP Conroe and worldwide on the irlonestar.com.
Good afternoon and welcome to The Legal Connection with Toni and Cheryl. Toni Lynn Collins, Cheryl Ellsworth Jahani. We are here every Tuesday from 12 to 1 p.m. on Conroe's FM 104.5 and 106.1. And you can also download the podcast tomorrow if you go to irlonestar.com, and you can get it on Google Play or iTunes. And if you're interested, you can watch us live on Facebook and live message us too. And if we get a chance, we'll get to your questions. So Toni and I today are going to be talking about various legal topics. But one of the first things that we wanted to talk about is the SLAPP law. There is something in Texas from the Texas Citizens Participation Act, and it's called SLAPP. And it's a strategic lawsuit against public participation. It's pretty heavy. A SLAPP is a lawsuit that is intended to censor, intimidate, and silence critics. Now, this is just Wikipedia. And silence critics by burdening them with the cost of a legal defense until they abandon their criticism or opposition. And the reason we want to talk about it today is that as a result of SLAPP, there's an anti-SLAPP law, and then there were some changes made to it, and they're going to go into effect, or they just recently went into effect, I think September 1st, that Governor Greg Abbott signed. So let's see. Anti-SLAPP allows you to counter a SLAPP suit against you based on your statements in exercise of your right of free speech, petition, or association. So, in other words, if you defame someone and you get hit with a SLAPP suit, then you can anti-SLAPP and you can say, no, that was my right of free speech. That's my constitutional right. Whatever. You know, you can defend yourself, and it's pretty far-reaching. And so what happened after the anti-SLAPP, I think it went into effect in 2004, people just went crazy with this anti-SLAPP thing, and the courts began to use it as this umbrella to let people get away with all sorts of defamation or things that used to be considered defamation until we had the anti-SLAPP law. So it's interesting because Greg Abbott just signed, let's see, hang on one second, guys. Texas Governor Greg Abbott signed a bill that he signed it on June 2nd, and it makes several changes to the Texas Citizens Participation Act, but leaves intact many core elements of the act that opponents had targeted. The adopted legislation does not include some of the most alarming elements from the first draft of the bill. The lawmakers agreed to abandon an amendment that would have allowed parties filing meritless cases to avoid paying a defendant's legal expenses by dropping a lawsuit prior to the hearing. So there were some pretty serious curtailments in the anti-SLAPP. It was very broad, but the new law that Abbott just signed in was in effect yesterday, I believe, also constrains anti-SLAPP protections in many ways. Whereas the original Texas Citizens Participation Act allowed defendants to seek dismissal for issues broadly related to the right of free speech, so that's broad language. Broadly related to the right of free speech, petition, or association, the new statute requires the claim to be more narrowly based on a violation of one of those rights, so like free speech, participation with whoever you want to hang out with or whatever. Legislators abandoned anti-SLAPP protections for speech regarding trade secrets or non-compete agreements, potentially allowing employers to intimidate whistleblowers with employment-related suits. So that's interesting. The new law goes into effect September 1st, so it was just the other day. Also, the 2019 session of the Texas legislature is currently considering legislation that could threaten the public's right to speak freely on public issues. We really need to watch out for these things. That's not good.
Well, let me turn my thing in here. The anti-SLAPP, it's come up so much with in the recent cases I've been dealing with. I was just as an attorney, I was reading about, I love to read about the bar disciplines and the disbarments, and you on the one hand, it's interesting. On the other hand, the disciplinary committee gets, it's serious. All right, and I'm going to give you an example. When I get, whenever I'm doing a really good job in a case, I get a grievance filed against me by the other side.
Right. Which
is sort of a badge of honor, really. When I get one of those big old packets in the mail from the bar that says, you don't even know they filed a grievance. You get the grievance packet, but by the time you've gotten it, because you're not in the loop, these people are, typing in their grievance or whatever, you don't know about it, they've already dismissed it. So all mine get dismissed, and basically, and they'll show you what the person said. And sometimes they get crazy, and they put it in a CD. I mean, they just go, maybe it's a good kind of therapeutic thing that they're not going out with a gun or something, but they're writing the bar about their anxiety about their case. And I'm just the fall guy, okay, because I'm not going to take it personally, whatever they're, it's just work, right?
Right.
And so I'll see what these people have written, and generally I haven't done anything wrong. In fact, I've done my job, and so I'm happy that, justice has been done.
Right.
But then a case that just came out that was up on appeal, an attorney was sued by and it's a lawsuit whether you're a doctor or you're a lawyer. If you've got a profession, you've got a board generally in Texas. If there's an oversight by a governing body, if you have to take a license to pass something, you've got a committee.
Target. You've got a target on your back.
No, it's not what I was thinking.
Oh, okay.
Police, lawyers, doctors, professionals that have to, real estate brokers, professionals
have
that
licenses.
have to have a license. There usually is an overseeing commission with the state that is making sure that you're doing the right things.
Okay.
And the general public, plumbers, electricians, if they're upset, they can file a grievance against you if they
Right.
don't file a lawsuit. Well, a grievance is it may affect your license, but it could also go a step further, right? And so in this particular...
In other words, you could lose your license. Is that
Right,
what
you
you
can
mean?
lose your license, or when I'm saying a step further, losing your license is a pretty big deal, but a step further is they will take you to court for whatever you did. So you've got lots of alternatives if you're unhappy with somebody. You can sue them. You can file a grievance against them. I mean, there's steps to different levels, like a little going upstairs, I guess, of what you want to do. And really, when you have an issue with somebody, you have to sort of assess what's your best,
Mode of complaint.
what is your best action to get satisfaction out of this? Because for the most part, we're lawyers, so we get to hear lots of complaints. And part of our job is to listen to people and determine whether or not they've got a case that should be in court, or maybe they need to get over it, or maybe they need to go to a counselor, or maybe they're the ones with the problem. So you're analyzing whether they can prevail in court, and that's a lot of times why we have to pay for, or people have to pay us for their consulting fees,
Right.
because we turn into a therapist. And I do I do free consultations, but I do them while I'm on the road between counties going to different courts, because I figure I can help people that way, and maybe we can keep cases out of court that shouldn't be in court, right? Now, in this particular case, though, and we're talking about the anti-SLAPP law, just a circumstance that came up, there was an attorney that was not really doing what he should have done. It was definitely something I wouldn't have thought about doing. And what he did was he sent, in fact, I have the case here, he sent letters to a bunch of medical clinics telling them that they were not in compliance with their websites weren't in compliance. In fact, let me read what they said because it's better just to hear it verbatim so you'll understand why this was of a concern and how we're going to apply it to everyone's lives, not just attorneys. There was an attorney named Rosales, was his last name, and he sent letters to several healthcare facilities claiming that their websites did not meet the requirements of the Americans with Disabilities Act. Their website didn't.
Oh, good.
Right. You know, like a website would have anything to do with somebody that was in a
Right.
wheelchair. He also attached a proposed lawsuit that he said he was going to file against them unless they paid him $2,000. Well, that's extortion. Okay, so
Golly.
that's not just a
Solicitation
lawsuit. That's a
of business.
crime. I mean
Yeah.
that's a crime. You don't try. That's like what that guy did. The one that represented the stripper and Trump. What was her name? Stormy Daniels.
Yeah.
He did the same thing. He was trying to extort Nike and various things. And when you're a bad person like that, it will come back to get you.
Oh,
I mean,
right.
you should always do the right thing. And what he was doing was the wrong thing, like this attorney was doing the wrong thing. Okay. So he signed the letters, O. Rosales, attorney at law. And of course, I can talk about this because it's in a publication, and so it's already
Sure.
news, right? And several providers filed grievances against Rosales with the Office of the Chief Disciplinary Counsel of the State Bar of Texas. That's just a long word for I Googled State Bar, and they have a place where you can look for
File a
grievances,
grievance.
right?
And so several, huh?
A bunch. And again, I've gotten grievances filed against
But
me.
it's different when there's several, that they're going to pay more
Well, I mean,
attention.
I've had several too, but not on the same issue.
That's what I
will
mean.
get them I'll get a grievance filed against me about maybe sometimes 2 or 3 times a year. Not that often because I'm not doing anything wrong. And I know I'm not. That's why I'm not afraid of them.
Right.
And I understand people's feelings get hurt and what have you, and they have to have an outlet. And they're particularly upset if they didn't win their case and they take it personally. But I'm just the attorney, I always get the dismissal, and I file them in my alphabetical order now in my little dismissal file. And every now and then, for fun, I'll just pull them out and read them.
Yeah.
But anyway, but this guy really needed a grievance filed against him, and it goes for other commissions. You can file grievances against. I'm assuming police officers. I've never filed one, but if you are anyone
Or a
that has to,
doctor.
real estate agents, brokers, if you believe that they've done something wrong, okay, but. And whenever you file these grievances, to kind of go down that rabbit trail a little bit, in order to make it stick, if you have a legitimate gripe, you have to look at what they did not comply with in the code of their license. So if you just randomly complain, you're not going to get anywhere. But if you go to, let's say, the real estate commission, and real estate agents have to do certain things, they, for example, on their sign have to say, if they can't just say the agent's name, they have to have on the bottom the broker's name, who the agent actually is under. Or they have to have in big print, there are just certain things they have to do in their advertising. And just there's a whole slew of things you're supposed to do when you sell a house that people don't do. If they didn't provide a disclosure, that's a really big one.
Right.
They didn't ask because they knew that the house had been flooded 5 times, and the last time was Harvey, and all they did was patched it with putty or something. Well, they need to disclose when there was damage, or if
Right.
there was a fire or something.
Right. And they didn't do that.
And the agent may have known about it because they're friends with them, or maybe it's the agent's house, and they don't disclose that, and they're going to get in trouble. And so they'll not only have a lawsuit, but they'll have a grievance that they can file with the real estate commission, and this person may be sanctioned or lose their license, right? Okay, so anyway, eventually the state bar filed suit against Rosales. So they took it up like you would do in any commission, and they sued on behalf of the injured parties that were getting these
Right.
letters, okay? Rosales filed a motion to dismiss under the Texas anti-SLAPP suit, and it's called the TCPA, which also is a bunch of other statutes. It's also the Telecommunications Programming Act or something. So, but this one is the Texas Citizens Participation Act. Okay, so if you look it up, if you ever anti-SLAPP, those are kind of synonymous; they go together. The state bar responded that the TCPA did not apply to lawyer disciplinary proceedings, and even if it did, they met their burden to show clear and specific evidence. A prima facie case for each essential element met the claim. In other words, the state bar is saying, you're not going to get anywhere with this dismissal because we've got a claim against you, and we're big, and we know our business, and we don't go around suing people unless we think it's really important.
Right.
So, and you'll also see these Texas disciplinary, the Office of the Chief Disciplinary Counsel. If you were just to Google that, it'll come up as the plaintiff when people are being disbarred or attorneys are being disbarred.
Right.
And we had a recent one over here in the 284th that came up when I was researching this. for a gal, I was watching her YouTube. She defended herself, which is really pretty dangerous if you know.
I'm about to lose your license,
Yeah,
or that's at stake.
and what she did, and what a lot of attorneys lose their license over is because they don't put their money in their AOLTA accounts, or they're using their clients' money because they're thinking, well, they gave me the retainer and I need to pay my bills, and it's a hefty retainer, and they're not. They get swamped, and then they don't keep in contact with their
Well,
client.
so let's tell our listeners what an IOLTA account is. It's a trust account that attorneys are required to have. I used to know what IOLTA stood for, but I'm sure it's trust
make it up.
account at the end, TA. And when an attorney gets a retainer from someone, that's money you haven't earned yet. Say like, Tony,
It
I
stands for something
hired-
like interest-bearing legal something, because it's an interest-bearing account where the interest goes to the state bar.
it goes to for like free legal aid.
Right.
And so anyway, we're required to put those funds in that IOLTA account, and then as we work for it, we draw the money out of the IOLTA and into our business operating account
right.
or wherever we do it.
Right.
So those funds, the retainer funds, are held in trust.
Right.
Until they're earned.
But it's usually now it can be different. If you get paid by the month, then you don't have a retainer. So there's some ways where you're not in breach if you don't put that money in the account. Let's say you did the same job, you got paid that day. It's not a retainer, you've already earned
Right,
it. Okay.
right.
So there's different ways you do it. But in this particular instance, this gal that just got disbarred, and she was like my age. I mean, she'd been.
What happened?
She was court appointed, and she was representing people in probate estates, amongst other cases. And she was representing, she was the guardian, or she was the ad litem. And because this person was really old and really rich, and I guess there was a few of them, but in one in particular, she was just taking money out of the account like crazy. And I guess she wasn't explaining it very well. And ultimately, it did appear to the court that was wrong. That
Out of what account?
the trust account for her, the person that she was representing, her ad-lib. Yeah, and the person wouldn't have known because they were incapacitated, but the family knew, and the family didn't even know to look, and so it was kind of like she did it for long enough, I guess one of my drug addicts that they're told on probation you can't do drugs, and then they let it slide because they're smoking pot or doing coke or something, but they get enough marks against them that one day that probation officer decides to turn them in to the court. I get so many clients say, "Oh, my probation officer is so great," and they don't call them that; they call them their something. It's some slang name for it, but for them. But it ends up that if you get drug tested enough, or if you breach enough of the issues that there's a long list of things you can't do if you're on deferred or on probation. If they let it slide enough, at some point it's all going to be cumulative, just like at school. If you fail enough tests, but you don't get turned in to think you're going to be nice. That your probation officer is being nice. Well, they may just be being mean because they're making it so that you can't defend yourself, because it's not just one issue now. It's so many that you could never say that.
And they're keeping track of all of those.
Yes, right. So people that are on probation or pretrial diversion or any of those things, don't think you're getting away with that one little slip up or that one bad drug test, because you're not.
I have never had a client that the probation officer let it accumulate.
I have had a number of them,
Really?
and they're usually
Was that in Harris?
In
County?
Harris, only in Harris. Yes,
Yeah.
They don't get away with that in Montgomery County, but they really are trying to be nice. That's the thing, is their probation officers are trying to work with them.
Well, I'm glad to hear that.
But the problem is that these people aren't behaving
right,
and
consistently.
but usually they need help too. They're usually drug addicts, and the probation officer does eventually turn them in, not because they're not being their friend, but because they may have a problem, and we know how that goes. And I will say this: cocaine is like the worst thing. My clients that do cocaine and meth. I do have a lot of clients that do cocaine and meth, but they need representation, and I represent them.
Sure.
I usually don't know that they're addicts when I take on their cases, but I learned that once they flunk so many drug tests,
Right.
that I can see that they need help. If I know that up front, then I immediately send them to counseling. So anyway, how much time do we have before our next break? Finish my okay. Well, let me finish up the deal that happened with our disciplinary
attorney.
action. Right. Okay.
So what happened?
So what happened is the state bar responded saying, "Hey, we have a good case here. this attorney thinks he's so smart, he's going to file the dismissal of this case within 60 days, and which is the anti-SLAPP.
But what was his basis for the anti-SLAPP? I mean, was he saying I have a right to say whatever I want? Or?
Yes, and we're going to get to that. This article explains it much better than I did. But the Texas anti-SLAPP law has a 3-step process. In step 1, the movement bears the burden of establishing by the preponderance of evidence that the non-movement's claim is a legal action. In other words, the person that's moving for this to be dismissed is the party that that did it. Okay, so the state bar is saying on behalf of all the medical facilities, hey, you can't do this. You're a bad person, and then the attorney, or whoever it may be, in this instance was an attorney, turned around and filed a dismissal, and you have to do it within 60 days, saying, hey, I was just exercising my First Amendment rights. I wasn't trying to get them in trouble, but I have a right to do what I was doing. And this attorney basically said, I have a right to let them know that they are breaking the law, the American Disabilities Act, with their website, because maybe the print's too small, or whatever they were doing. And so, but he really wasn't. He was extorting people, and so it was a way. They were using the law the wrong way. And so the state bar said, we're not letting you get away with that, and we're a bunch of lawyers too. So let's go. We're going to go spar in court over this, and they did in the appellate court. And so again, the movement in this action was the bad guy. Okay. So in step 1, the movement bears the burden of establishing by the preponderance of the evidence. I'm sorry, not the bad guy.
But he is the movement, though, because he was using the
I'm sorry.
anti-SLAPP,
That
right?
the non-movement's claim is a legal action in response to the movement's exercise of its association for free right. That always confuses me, the movement, non-movement. Okay.
The wording is...
Okay, so but basically it's the person that has done the deed that is not good, has 60 days to come back with an anti-SLAPP and say, I haven't done anything wrong. I didn't slap you.
It was my constitutional right.
My constitutional right. And so if they do it within 60 days, if this person that wants to, and that's basically what it amounts to, you can go around defaming people with this particular law. And if you fall into the right categories of the law, then you're getting away with defamation. And that's not right either. The law was actually set up to allow people to have free speech, and to exercise their constitutional rights, and to keep a lot of frivolous cases out of the courts because there's no injury.
Right.
Oh, he called me a sissy. I'm going to sue you. I felt like you really meant that I was gay or something. And then you would anti-SLAPP because the person didn't even do anything by saying, there is nothing to this case. I want it to go away. And if they lose on the anti-SLAPP, though, the problem is it's good for the sissy case because they shouldn't have to even be in court for that. But it's bad if there's a legitimate defamation or a legitimate bad act going on, because if the court dismisses it, then the person that is now injured twice, because not only they've been defamed, but they have to pay the attorney's fees.
Exactly.
Okay?
Right.
And so the first step is the person that's filing that's coming back to defend themselves, they've already been injured once, has to file a claim. So the movement bears the burden of establishing by the preponderance of the evidence that the non-movement's claim is a legal action in response to the non-movement. But that's still just too confusing to me.
Well, no, it's saying that the movement has, like the bar is the movement,
Right.
pretend. And so they bear the burden of showing that they have a valid claim against this attorney. This
Right.
attorney's saying
Right.
anti-SLAPP, and the bar comes back and says, no, not anti-SLAPP. This is a real case.
Right. So the first
just
step
like you were
is
saying.
the first step is the person that's been injured saying, this is defamation or this is extortion.
Right.
Okay. So look, they did meet their burden on that. They said, this is extortion. What are you kidding me?
Yeah.
Okay. Then the state bar first argued that the Texas Participation Act Texas Citizens TCPA did not apply because it exempts from its applicability, quote, an enforcement action that is brought in the name of the state or a political subdivision of the state by the attorney general, a district attorney, or criminal district attorney, or a county attorney. So in other words,
Immunity.
yeah, the police can arrest you and they won't get an anti-SLAPP case for
Right.
criminal or whatever
Because they were doing their job.
They're just doing their job, right? The appeals court noted that the chief disciplinary counsel was neither the attorney general, a district attorney, a criminal district attorney, or a county attorney.
Really?
And according to the court, the exemption did not apply to the state bar. Now, this raised the ire of the state bar because there were a bunch of attorneys, right? The chief disciplinary counsel's office next argued that they were immune from the TCPA and that Rule 1709 of the Texas Rules of Disciplinary Procedure, which is what they were going, which was they were ticking off saying that this guy did wrong. The court ruled that the Chief Disciplinary Counsel's office was not immune from the application of the TCPA, since the immunity that they relied on was for individuals and applies only to government employees. So they didn't get it. They're saying your step one is gone. You're not immune, and you haven't given us a case yet. Or
Right.
I mean, that was part of their argument. I didn't see what their application looked like, but it seemed to me the extortion would have been a valid, case, and they would have been able to go forward with that. All right, so once the movement, which in this case is a state bar, has shown that the non-movement's legal action is covered by the act, so then
In other words, the extortion is covered by the act.
right, the burden shifts to the extortioner or extortionist to demonstrate a prima facie case for each essential element of the action by clear and specific evidence. Okay, so now all right, so extortion is bad, even though it's a civil issue and it's not a criminal issue. So that now that we have shown them, then we need to bounce back. Okay, so are we taking a little break? All right, so we will.
All right. Well, Toni and I are here today. Right now, we're talking about anti-SLAPP and the changes that have happened to it just 2 days ago. And we will be right back after the break.
From the beginning, the main purpose of the Cooperative Extension Service has been to change human behavior by teaching people how to apply the results of scientific research. By utilizing a holistic, multi-level approach, Extension family and community health programs encourage health and well-being for everyone. Addressing values, concerns, and needs with reliable science-based information, Extension programs help people lead healthier lives. We are Texas A&M AgriLife Extension, helping Texans make their lives better.
Our talk shows and music shows are looking for sponsors. Want to expand your brand awareness? Reach the hyper-local audience in Montgomery County? Lone Star Community Radio sponsorships accomplish this. Want to see our stats and rates? Check out ourlonestar.com/sponsor for more information. Or call in and leave us a message at 936-647-3776 with your questions. Get seen on TV, YouTube, and heard on our podcast, FM, and internet radio. Support your local radio station with Lone Star Community Radio.
Have a legal question? Are you a resident of Montgomery County? Call 281-645-6344 to talk to a volunteer attorney from the Woodlands Bar Association. We answer the phones on the first Monday of every month at 281-645-6344 from 5 p.m. to 8 p.m. to provide general legal information and information about legal resources to Montgomery County residents.
Listen in Mondays at noon to hear Conroe news from local nonprofits, businesses, upcoming events, Conroe Park events, news stories, and information that matters to you with your host, Margie Taylor of Taylorized PR. For more information about being a guest, visit irlonestar.com/Conroe Culture.
Don't miss Lone Star Community Radio on TV and YouTube. Our talk show and music shows are featured on Our City TV, Suddenlink Channel 12, and have their own YouTube channel. Make sure to subscribe to keep up with posted shows and comment on them below the video.
Welcome back to the Legal Connection with Toni and Cheryl. Toni and I are here today talking about SLAPP and anti-SLAPP and the new narrowing of the Texas anti-SLAPP that just happened 2 days ago,
Right,
signed by
and
Greg Abbott.
I have got two different clients that are having to deal with anti-SLAPP right now, and that's kind of weird that, I do a lot of DWIs, which are a lot more prevalent than anti-SLAPP. Anti-SLAPP didn't even exist when I went to law school. So
Yeah.
this was a fairly new way to I guess, cut the caseload for frivolous cases for different areas, defamation or, bad acts or whatever, because they're really not bad acts. It's just somebody mad and they want to sue. Well, you can sue over a ham sandwich, as they say. You can not only indict, but you can sue, which is kind of like a suit. And I had one client that where there was a defamatory letter sent to his different colleagues within his medical practice that was really slanderous, and it was done by a large corporation, their attorney, in order to injure him, only so that he wouldn't, so he couldn't work, so they could have control over him. It was a really bad. It was manipulative. It was bad. It wasn't done in good faith. It was a letter that had defamatory statements in it that was in no way true, that went on, and it didn't even, what they said, they didn't even have a witness.
So opposing counsel in this case against this healthcare provider sends out defamatory letters to his colleagues,
and people that he was
him.
working with, so they wouldn't want to work with him. Very similar to a case that they just had in the medical center where there was a heart surgeon who had left I think it was, I forgot what hospital it was. He had left one of the bigger hospitals, and he'd gone to a different one, and he was very renowned. And they sent letters out on the review saying that he didn't have a good peer review. That's very important for doctors.
That's very confidential.
Yes, and so he sued saying breach of confidentiality, defamation, and it was a long, hard-fought battle, because how do you get people to discuss what's on a peer review? You can't. It's confidential. He ended up winning a lot of money.
Good.
Because he stood up for his rights, and that's what people have to do when you're defamed. You can just be kind of quiet about it and let people just defame you. But the truth of the matter is, if your livelihood is at stake, you can't sit back. You have to fight, because you didn't do anything wrong, and somebody's getting away with throwing, dirt at you.
Right.
It's one thing if you're a political figure, but if you're in private practice, and somebody's mad because you left their practice, or they're mad because you've got a winning lawsuit against them and they're trying to destroy
jealous of you because you're doing better than they are.
And then they write a 2-page single-space letter to the different physicians that you work with and the different, not customers, but we get out to customers saying that you're not a very good physician, when the reality is you are an amazing physician. That's something that should be stopped and should be they should be turned in, whether it be to the bar or it be in a lawsuit. Well, what happened was so a lawsuit was filed, a defamation suit, because that was clear defamation.
Right.
And when we went to court, it was over here in Montgomery County. The judge said, and she's not on the bench anymore, but she said, well, I think that's a public concern. And since it's a public concern, I think that's covered by the anti-SLAPP, and they're just exercising their First Amendment rights to defame you.
So it was a public concern because the guy was a healthcare provider, and the public needed to know.
It wasn't even true. It was all lies, and there wasn't even a witness.
Unbelievable.
The witness wasn't provided. There was no witness on their witness list. It was just made up. And the judge said, well, I'm going to dismiss it, and I'm going to. And per this suit, if your case gets dismissed under anti-SLAPP, you have to pay the attorney's fees, even if they're minimal. But if they charge $700 an hour, they're pretty high. And so that what's wrong is it's preventing people that are truly defamed and are wronged from being able to have any redress or recourse
They're wrong
in the legal
twice.
system. Yeah, they're wrong twice, and so that's really wrong. And so anti-SLAPP was too broad, because what's a public concern? It could be anything.
Yeah.
And so many of these cases are being overturned, and they're trying to change the law so the whole law doesn't go down the tubes, because it does have a place where you don't want to bring just frivolous cases, but you can't go after somebody just because they're a doctor or a lawyer, and try to injure them because you're jealous or for whatever the reason, because you're big, because you want to win the case, you want to ruin them, like you say, whatever the case may be. So, in this particular instance, though,
with the attorney against the bar, what happened?
And I'll add one other thing. The other case, and I'm working with this with a radio personality, not like us, but this person had been defamed before they were on the radio, and their case was dismissed. Because they said they were a public figure, but they weren't when it happened. So it was a timing issue. So that was all wrong.
Oh, okay.
So, okay.
So wait, so that case with the radio personality, someone defamed them, and then they said, "Oh no, it's a matter of public interest.
Yes.
We really didn't defame them." What happened, or is it ongoing?
The court dismissed it improperly.
Yeah,
because
anti-SLAPP's too broad.
And it also is, and it's really sad to say, but a lot of times, like we were talking about this morning, it's who you know, and with the court. And it's kind of sad. It's just like, and real quick, this morning we went to go do an adult adoption, and I ran late because this court moved their hours up. But you no longer got there, had to be there at 8:30, had to be there at 8. And so by the time I got there, they said they couldn't do it. And, we knew that there was just a rubber stamp. Adult adoptions are they're a little bit paper intensive, but they're an uncontested, and so you go to the uncontested docket, and any judge can pretty much do them. That an associate judge can say, well, I'm busy right now, go to the next. I'm going to give this case to a different court's associate judge. So if you got all the paperwork filed properly, it's just something you have to do. And so we went there, and the clerk said, I'm sorry, but you've missed the uncontested docket, and you'll have to come back tomorrow. Well, it was, an hour drive in for me. It was an hour drive in for all 3 of my clients. They all had to be there. And then that was an hour drive back, and the time expended. And they didn't have time to do it before they went on their vacation. So it was really bad. So we left, and we didn't leave before I begged. And I wasn't that persuasive, to get it done. But then one of the security guards for the court had come out for a minute to go to the bathroom, and he had been talking. It's always good to be friendly with everybody. He had been talking with my clients. Well, they're all my clients, but the mom, the biological mother, and was just small talk. And she's like, "That's the guy. That's the guy." He said, "I'm like, I loved it. This is great." So I was like, hey. And so we were like, "Thank you. Can we just please?" And we asked, and he was like, "Oh, come on in." And so because she was nice, it always is good to be nice to people. Because she was very nice, and he remembered him, because we were so thankful that guy opened the door, even because you can't get into the associates doors in Harris County. They locked them. You have to be let in. We went in, and the judge was amazing. It was the daughter of another attorney I used to work with, and she had known she would have let us in a second, but the clerk was just being the gatekeeper.
Right.
We got it done in like 5 minutes. And so the word that what you learn from this is be nice to everybody in the court, everybody, because you don't know what's going to help you.
Right.
Number 2 is sometimes it can be done if you really stick with it and do it and don't give up. And third, sometimes the clerks, even when they mean well, can make the wrong decision. And in this case, it would have been the wrong decision because it was literally a 5-minute, deal, and we had all the paperwork done, and it saved everybody so much time. But now, that being said, gatekeepers are really important. Step 2. Step 1 was that for the anti-SLAPP is that the person that has been injured in our scenario here with the state bar, or the group of people the state bar is representing, has now filed a claim. And the bad guy here came back and said, "Oh, no, I filed this within 60 days, and I've got my free right to tell these people that they're making a mistake, and I shouldn't be injured just for having people uphold the law, even if I'm extorting them while I do it." So step 2, though, is that the burden was met, that they did have a claim. Okay. So step 2 is once the movement has shown that the non-movement's legal action is covered by the act, which in this case it was, the burden shifts to the non-movement to demonstrate that a prima facie case for each essential element of the cause of action by clear and specific evidence. So now the other side has to show all the elements of that particular action against them is demonstrated, right? Okay. So the elements of professional misconduct, to show you what he argued.
Okay.
The elements of professional misconduct claim are, number 1, the respondent is an attorney licensed to practice law in Texas. Okay, so that was met. Number 2, who engages in acts and conduct that violate the disciplinary commission. And so the state bar is having to prove this, not the other guy. The state bar now has this. I guess the first guy had to show that he was within the anti-SLAPP statute, and now the state bar has to come back and say, "Oh no, this is why we have a valid claim," and we can meet each one of them clear and specifically.
Right.
The respondent's an attorney. He engaged in acts that violate the
disciplinary rules.
Commission, and it's in little tiny wording right here. Given the existence of the letter in the record, which was the bad letter to the healthcare facilities, with its related demonstrable facts and the commission's detailed pleadings regarding the basis of its claims, we hold that the commission carried its burden under the TCPA to establish by clear and specific evidence a prima I never know how to say that. Prima facie.
Prima facie.
Prima facie. Prima facie. Because
I would say prima facie.
All of my, everybody I've heard it say different, but my in law school, the courses I took, they were prima facie. So I don't know. We'll have to go look at, do Wiki or Ask Alexa or
Just
something.
ask me. It's prima facie.
Okay. We'll let our station manager real quick listen to what Alexa says, because she's always right. She knows everything, too. That's just crazy. The good thing we let her, invade our privacy at home. She can answer our questions. Anyway, that they established the case that Rosales engaged in professional misconduct by violating the Texas disciplinary rules of professional conduct. Okay, so one guy said, the first guy said, hey, or the disciplinary committee said, we have fallen into, what is the first step? The first step is the bad guy has to say, I fall within the act. Anti-SLAPP covers me, public concern, whatever. And we're going to talk about those in a second, what the elements are for anti-SLAPP. And then the state bar came back and said, oh, no, we have by step 2, we have met all the requirements to show that he's a bad guy and our claims are legitimate. And so it's not anti-SLAPP. Or he's not going to be able to dismiss this case until we go to court for it. Okay?
Right.
Step 3, there's only 3 steps. If the non-movement meets his burden of establishing
Prima facie
case for each essential element of a cause of action by clear and specific evidence, the court must still grant the motion to dismiss if the movement establishes a valid defense. And so, of course, the movement is the one wanting to dismiss it. Okay, so the non-movement
using the anti-SLAPP.
Using the anti-SLAPP law, right. And so now the burden changes again. Now it's preponderance of the evidence. All these burdens are different for each step.
Yeah.
So and that's also in the statute, the anti-SLAPP statute, which keeps changing. It's a moving target. So you want to look at it all the time now if somebody's defamed you or if somebody has filed against you improperly. It goes both ways, right? Okay. So Rosales did not establish by a preponderance of the evidence that his demand letter does not violate Rule 8.04A3, prohibition against engaging in conduct involving dishonestly, fraud, deceit, or misrepresentation. Because that's what they were saying that he had done, that he was doing. You're sending letters to healthcare facilities that they are not properly complying with the American Disabilities Act. And come on, really, on the internet, how can their websites not comply? I mean, just go in. I mean, it's not like you don't have a ramp or something. So anyway, according to the commission's pleadings, Rosales' letter violated this rule by 1, stating categorically that the ADA applies to websites and that the ADA requires compliance with the WCAG guidelines, when in actuality there is, at best, a split authority as to whether or how the ADA applies to websites. So there you go, people that have websites in their healthcare facilities, it may not apply to you anyway.
What year was this? Did this happen?
This happened.
Was it this year?
It just went. This was just in the appellate courts.
Okay.
So it just came out.
Good.
In fact, what year? 2019, I think April.
Okay.
2, referring to the WCAG guidelines as rules that the recipient's website has failed to comply with, when in actuality the WCAG are guidelines established in the private sector, not rules promulgated under the ADA. Okay, so in other words, he had a very broad letter, and it didn't even apply here to the private sector. And 3, suggesting that the WCAG guidelines constitute a policing agency for the ADA and the ADA compliance, when in actuality the WCAG guidelines are a set of suggested guidelines maintained by a non-governmental entity. The commission also pleaded that Rosales' use of the trade name Center for Veterans Access, an attorney is
that what he filed the
Yes.
letter on? Sent the letter
He has a
under?
DBA. We were talking about that last deal. His DBA was, as an attorney, the Center for Veterans Access. That's pretty deceptive too. In a letter, is deceptive in violation of this rule because it suggests some relation to the U.S. Department of Veterans Affairs. This guy was just doing it all wrong. Mom and pop places that have their own little website don't have to worry about not complying with the ADA through this. And so there were so many things that he did wrong that the bar really doesn't file grievances against people. And I know that firsthand because mine are all dismissed. And,
Sure.
But they're looking at this to do the right thing and not waste their time if the lawyers are doing bad things. Okay, so conclusion and disposition. The Texas anti-SLAPP law applies to lawyer discipline. So the effectively what happened in this case, and I printed the case out, is a trial court dismissed the case under anti-SLAPP. They said, okay, the guy's right. The bad attorney's
The
right.
first case.
Yeah, he said he filed
That's
it
why
within
they were in
60
the
days.
appellate court. Okay.
And because the state bar got mad, and they said, you can't legitimately think we don't have a case against this guy. We're telling you, as the disciplinary policing agency of attorneys, we have a case, and you dismissed it against us?
Wow.
I mean, that's pretty bad. And so they were like, they got their muscle together, and they were like, oh, no. They probably had a first-year lawyer because this would have been a pretty, they probably didn't. But if they did, a first-year lawyer could have argued because that's pretty bad, extorting people under those guidelines. So the TCPA applies to lawyer discipline cases. But before everybody goes off, this guy is following rampage, the essential elements of the cause of action for lawyer discipline is very easy for the state bar to meet here. Unless there is no basis for the state bar's claim for discipline, in which case it should be dismissed anyway, the state bar will easily meet its burden under the Step 2 of the Texas anti-SLAPP law. And this is what the dissent stated, and I'm not sure why this isn't the dissent when they got the reversal, but the Citizens Participation Act is a statute with express purpose of protecting the right to petition, speak freely, associate freely, and otherwise participate in government, has become a barrier to disciplining lawyers for violating the disciplinary rules of professional conduct. It is not a barrier to disciplining lawyers. You have a right to do it anyway. If Rosales had filed a no evidence motion for summary judgment and the state bar did not respond, would the suit be dismissed? Could we say that summary judgment has become a barrier to disciplining lawyers? And that's another way to get rid of it. If he knew the judge,
That's right.
he could still have gotten it done that way too. New things are scary, but like we would tell our client, just do what you're supposed to do under the law and everything will be all right. Well, you say that, but really the truth of the matter is it's only going to be all right when, this was April of 2019, if you don't give up. That's the key thing. And so in this case, yes, the Texas legislature passed TCPA to encourage and safeguard, just like I said, the constitutional rights of persons to petition freely, but it can't be used against them in this, it can't be used for the position of hurting somebody with, what's the term I'm looking for, with impunity.
But
But if they did reverse
punitively.
it, the state bar did win their case because they did have a case. And what do you have to tell us about this?
Well, this is a little old. This is from 2017, and I really already covered it at the very beginning. It just kind of lays out what slapped and sanctions it is. So that's, the original slap and then sanctions.
Right. But the bottom line here is that the appellate courts recognize that a public concern is far more narrow than this statute it was first written, because the judges just have to go by the letter of the law.
That's right.
But a lot of this is like crazy because that's not the letter of the law, and a lot of it's common sense. And so they have now changed the statute so that it's more limited, particularly in the private sector. And we're going to go over this again for what was specifically changed in the case that kind of got one of the primary cases that got the ball rolling on anti-SLAPP. No one should be allowed to. It's twofold. A person should not be allowed to go around defaming people for their own commercial benefit or to injure them because of this law
because they're-
and finding a loophole. And they think, this will be fun to watch them squirm just because they haven't jumped high. They won't, because they sued us because we did something wrong. We're going to get you back. On the other hand, people can't go around doing bad things and thinking they're going to get away with it because of anti-SLAPP too, because it's on both sides.
Right.
And the courts, if you don't give up, either the law will change or the courts will start ruling properly. Maybe the trial court didn't get right, but the appellate court, Texas Supreme Court, the United States Supreme Court will get it right. That's why we have higher level appellate courts, because sometimes they don't get it right. It may not be argued right, or maybe that someone's having a bad day, or maybe there's some money being pushed around in people's pockets. But that's why you should never give up. You should really fight the good fight. And sometimes, even if you fight the good fight, and maybe there was a mistake made in the legal procedures where you couldn't win on this one, you've at least established it for the next person that does get burnt. You've now kind of paved the way for it to be easier for them. So can't give up. Have to do the right thing.
That's right.
Pray about it. If you don't know if you're doing the right thing, that's what I always say. You have to always kind of go to the highest authority.
Okay, well, guys, listen, thank you for listening. Remember, you can download the podcast tomorrow on irlonestar.com and on Google Play and iTunes. And we want to remind you to always
Serve God by serving others.
have a great week.